This is a criminal defense attorney, Ryan Pacyga, and today I'm going to talk about a trial I just won, which was a third-degree criminal sexual conduct in Minnesota by force or coercion. The case actually started with an investigation when my client, a 17-year-old boy, allegedly had non-consensual sex with a girl that was a friend of his that was a year younger than him. So law enforcement began investigating this allegation after it was reported about 2 months after the alleged act. And law enforcement had it for a while, and then they gave it to the prosecution, and they didn't charge him until he was 19 years old. And of course, by that time, he's an adult, and so the Hennepin County Attorney's Office, which is downtown Minneapolis, actually tried to certify him as an adult at that point. So the first thing we had to do was fight that. I won on the certification trial, which meant that it went to EJJ, which is Extended Juvenile Jurisdiction, which means that they would have had control over him until his 21st birthday, and he would have picked up a record had he been convicted that would have been worse than a juvenile record. So that's not so good, and he would have faced potentially prison time as well. All right, they made an offer at one point saying if he pled guilty to that, he could avoid prison. He'd have to do some jail or something, but not actual prison. But we rejected that offer and went to trial because, of course, he was A, saying he didn't do it, and B, if you're found guilty or plead guilty to that, you have to register as a sex offender, and you've got a record of criminal sexual conduct, which is a rape conviction on your record. So at any rate, when this case became under investigation, at that point he had had some photographs with him and the accuser, not only on the day of the alleged act, but then for weeks and even a couple months after. And so I told him, give me your phone. We're going to power it down and we're going to preserve it. We're never going to open it again. And we're going to hold on to your phone as long as you are under investigation, so that if you are ever charged with a crime, we would be able to use these photos and these text messages from her without anybody arguing that the phone was manipulated or they were put on there later, or that the chain of custody over the phone was tainted, in other words. And that ended up being a really smart move, because lo and behold, we did use evidence from his phone in the form of photographs, videos, and text messages between them in the trial, and that is a big part of what helped the jury find him not guilty despite these allegations. All right? So that's a really important part. If you find yourself or a loved one under investigation for criminal sexual conduct, what you'll see in cases is that sometimes accusers will quickly delete messages or photos or other things on their phone or their social media that would tend to show a much different story than what they were saying happened. So if you're under investigation, make sure you preserve all that evidence as fast as you can. Screenshot it, download it, print it out, do whatever you can before it goes away, because if that's gone, such as some snap conversations or snap videos, you might not ever be able to get them back. In fact, you most likely won't be able to get them back. And get this, I told the prosecutor when he charged, hey, your accuser has some evidence on his phone that we have on our phone, and you should see her phone to corroborate this. Tend to be what's called Brady evidence, which is evidence that would tend to show that somebody's not guilty of what they're being accused of. Get this, the prosecutor said, we're not offering her phone into evidence. I said, wait a minute, this was information on her that would tend to show that that she's not telling you the truth, and that would tend to show that he didn't commit this crime. And they said, we're not going to go asking for it. That's her phone. We don't want to go. But they didn't even make an effort to go get it, which is just absolutely horrible. Can you imagine if you really didn't do something? And not only on your phone you've got some evidence to suggest that, but the other person's phone would have that as well, such as messages they sent to you, okay, that you might not have kept on your phone, but they have it on their phone, or things like that. And a prosecutor says, we're not interested in going to find the truth. That's what happened in this case. So don't believe for a minute, unfortunately, that every time there's a case that they're really out there to find all the evidence that might help to clear you or your loved one if you're accused of a crime. There are some prosecutors who will do the right thing about that, and law enforcement too. But unfortunately, there are also some prosecutors and even law enforcement who don't do that, either because they believe the other story and they don't want to go do the work, or because some, unfortunately, don't even care about the truth. Once they get a case charged out, they're going to run with that theory no matter what. Unfortunately, that's what happened in this case. When we got to trial, I was able to show the jury through cross-examination that the accuser was not being truthful with, convinced of that. Declined to do a full and fair investigation. They wanted to point their investigation in one direction and run with it. A couple of the people in law enforcement anyway, not all of them. And that compromised the integrity of the investigation, and the jury was able to see that. And finally, the prosecution even put up an expert witness to talk about things like rape myths and things like that, so that they can explain why someone, if they've been sexually assaulted, might not act the way afterwards you would expect them to act. And sometimes that's true, of course. Let's be real. Rapes, and some rapes do go unreported and things like that. That can happen. But also, unfortunately, there are some people who will tell lies. The studies out there show, they're all over the board on this, but even the state's expert conceded that even up to 10% of allegations are false right now, and that's under their own definitions, which is a very narrow definition. The reality is of course, unfortunately, sometimes there are going to be rapes that don't become solved, right? Things happen to kids that they report much later, you name it. Those things can happen, but just there are people who will make a false allegation for a whole lot of reasons, and those are horrific as well. And the state's expert tried to dismiss that, even the idea of that, but the jury saw through that as well, and they ended up not liking the state's expert in the case. So after a 2-week trial, the jury found our client not guilty of the charges in his case. He got his name back, he got his reputation back to a degree, but most importantly, he didn't pick up a criminal conviction, he didn't have to go to prison, didn't have to register as a sex offender and all those sorts of things. This 2-week trial, by the way, the jury deliberated an hour and a half was all it took. And that was because we were able to present that evidence and show them the rest of the story and the truth. And the jury was truly convinced that the accuser was not telling a truthful story. So if you're under investigation, begin to collect your evidence and keep it, because you may need that later, even a year or two later, you just don't know. That's a tip I have for you out there. If you or a loved one are going through an allegation of any sort of serious kind of case, whether it's criminal sexual conduct or anything else, feel free to give me a call. I'm criminal defense attorney Ryan Pacyga. You can reach me at 612-339-5844 or find me at arrestedmn.com.